So the ATF just suffered a major loss in the Texas case challenging the ATF's new rule on frames and receivers. So let's talk about this. But real quick before we jump into this video, if you think the ATF needs to be abolished, go ahead and hit that like button and subscribe. How's it going, everyone? My name is Anthony Miranda. I am a licensed and practicing attorney in the state of California with an emphasis on Second Amendment rights. I've been part of Second Amendment litigation both at a state level and also at a national level, while serving as a staff attorney with the Firearms Policy Coalition legal team. My goal with these videos is not to provide any legal advice, but instead to give you insight into the inner workings of Second Amendment litigation and to give you an idea of what's currently going on in the Second Amendment realm. As I mentioned in the intro, in this video, we're going to be discussing how the ATF just suffered another major loss in the Texas case challenging the ATF's new rule on frames and receivers. Blackhawk Manufacturing Group, aka 80% Arms, a very significant 80% company that manufactures these items, was just granted the ability to join this case and was named as a plaintiff, which the ATF desperately did not want to happen in this case. The case we're going to be talking about in this video is Vanderstock v. Garland. This is a lawsuit filed in the Northern District of Texas against the ATF and their new rule on frames and receivers, which went into effect in August. This whole lawsuit arose out of the ATF's creation of a new rule regulating unfinished frames and receivers. This new rule by the ATF is essentially a restriction on the sale of 80%er kits. Under this new rule, 80%er kits are treated to actually be firearms. This new rule went into the regulatory definition of what a firearm is, what an unfinished frame receiver is, what a frame and receiver is, and changed the definition through a web of references to include 80%er kits into the definition of an actual firearm. And since 80%er kits are considered to actually be firearms, they are now subject to serialization requirements and background checks as well. In this case, Vanderstock plaintiffs sued the ATF and are seeking for a federal court to find this new rule by the ATF invalid under the Second Amendment. In the lawsuit, the plaintiffs also requested a request for a preliminary injunction, and they are seeking essentially for the court to enjoin, i.e. to halt the enforcement of the ATF's new rule while this case is currently making its way through the process. On review, federal judge Reed O'Connor granted a limited preliminary injunction against the ATF in this case. In reaching his decision, he stated, ATF's new definition of frame or receiver is facially unlawful. The issue here, he states, is whether ATF may regulate a component as a frame or receiver even after ATF determines that the component in question is not a frame or receiver at the time of evaluation. Congress has not extended ATF's authority so far. That a firearm part is designed to be or may one day become a frame or receiver does not change the fact that in the moment, it is not the frame or receiver of any such weapon. So Judge O'Connor, looking at the ATF's new rule on frames or receivers, found essentially that it's facially invalid under the plain text of the statute and that Congress did not grant the ATF authority to regulate these types of items. So he granted a limited preliminary injunction in favor of one of the plaintiffs, Tactical Machining. Since his original injunction was limited in scope, the judge himself recognized that the injunction, which protected only the manufacturer of tactical machining, would still put the customers of that manufacturer at risk of potential felony prosecution if they purchased these items. However, he did allow the plaintiffs in Tactical Machining an opportunity to file motions for the injunction to be expanded to protect other plaintiffs and those customers as well. Then there was a battle between the ATF and the plaintiffs in this case about whether or not the injunction should be expanded. Judge O'Connor reviewed the arguments and issued his order granting the expansion of the injunction in part, but also he denied the expansion as well in part. He expanded the injunction to protect the individual named plaintiffs and also the customers of Tactical Machining. However, in the same order, the court denied the expansion to protect Firearms Policy Coalition and its members, and also the court denied a national injunction. This meant that Blackhawk Manufacturing, aka 80% Arms, as a member of FPC, would not be granted the expansion of the preliminary injunction to protect their actions against the ATF. In this case, Blackhawk Manufacturing sought to actually join the case as a named plaintiff. However, the ATF desperately opposed that and did not want that to happen because another manufacturer joining in this case as a plaintiff would expose them to the risk of an injunction or that same injunction being then expanded to protect that manufacturer and those customers as well, similar to how the court did with Tactical Machining in this case. In opposing the motion to intervene, the ATF argued that the request was not timely and that Blackhawk Manufacturing sought to only join this case after the court here in Texas granted that preliminary injunction in that one specific scenario for Tactical Machining. Well, the court issued its decision and found that 80% Arms has an interest in this case and also that their motion to intervene was timely. Therefore, 80% Arms was granted the ability to join this case as a named plaintiff, which is really big news and it is a good thing. In reaching this decision, the court stated, defendants argue only that Blackhawk should not be rewarded for its tactical behavior in declining to bring its own separate suit, to join prior lawsuits challenging the final rule, and in waiting a month to intervene, and that its conduct militates against granting intervention. But the court stated, as discussed above, however, the relevant inquiry here is how soon the movement intervened in the instant lawsuit after having learned its interest was at risk. Blackhawk's decision to forego intervention in a different case, or to bring an independent lawsuit or case, is irrelevant to the issue of timeliness in this specific case. The court stated, weighing all the above factors, Blackhawk's promptness to intervene, that the extent of Blackhawk's prejudice surpasses any inconvenience to the parties, and that no unusual circumstances militate against intervention. The court is satisfied that Blackhawk's motion is timely for the purposes of Rule 24. The court stated that, framed broadly, Blackhawk and plaintiffs do share the same objective: to successfully challenge the lawfulness of the ATF's final rule. So even if not a clear adversity of interest in terms of legal objective, Blackhawk's status as marketplace competitor to Tactical Machining, who is already wholly protected by the current preliminary injunction and without economic incentive to advocate expanded relief for its competitor, is a practical nuance sufficient to overcome this presumption. Therefore, the court went on to say that Blackhawk and 80% Arms, their interest is not adequately represented in this case because their competitor, Tactical Machining, was not likely going to advocate for one of its competitors to also be granted the same type of injunctive relief and protection, because again, they're competitors, so you can't expect Tactical Machining to have the same interest that their competitor would. And the only way to actually protect Blackhawk Manufacturing in their interest is to add them in as a plaintiff. The court stated that a competitor is not naturally going to advocate heavily for a different company, one of their competitors, and therefore 80% Arms needed to be added into this case as a plaintiff to actually protect their own interest. To me, that's really huge. This is a loud dinner bell essentially to all 80% manufacturers in the US that they should probably consider getting into this case as well, because their interests are not being adequately represented also. So one of the things with this case is the court already denied that national expansion, but one of the ways maybe to get around this is to have more companies, more manufacturers to jump into this case and to also seek the expansion of that preliminary injunction to protect their conduct against the ATF and to also protect their customers as well. Now, like I mentioned in my last video, one of the goals with Blackhawk was to join this case as a plaintiff and then likely to seek the expansion of the injunction that was already granted to Tactical Machining and its customers. I think the language in the granting of the motion to intervene would signal that the judge here is considering also expanding that injunction to protect 80% Arms or Blackhawk Manufacturing in this case. And that would be huge because that is one of the largest 80% manufacturers in the US, and you could have an injunction that protects that company and their customers as well from the ATF's new rule on frames and receivers. And I would not be surprised if a bunch of other manufacturers now decide that they want to try to get into this case as well. So that's a quick rundown of what's currently going on in this case challenging the ATF's new rule on frames and receivers. This is another solid win coming out of this case, and I suspect that we maybe have more coming. So if you have any questions, go ahead and comment down below and I'll try to answer best of my ability. You can ask questions like that Colton Miller asked in my last video, and he asked my thoughts on pineapple pizza. And my answer to that is no, pineapple absolutely does not belong on pizza. And if you think it does, then you are a weird person. So if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Algore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of 2A news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys directly impact these videos, impact this channel, helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by Armed Scholars, and this nation will be maintained by Armed Scholars.